Steven Freeland is a professor in international law at the University of Western Sydney here in Australia. He's also a visiting professional at the International Criminal Court at The Hague, and he's a member of the Transnational Enforcement of an International Environmental Law Committee of the International Law Association. He's published widely too on issues relevant to international law. I spoke to Professor Freeland a little earlier. Steven Freeland, thanks for coming in and talking to the world. The Australian activists on board the Shonan Maru have reportedly begun a hunger strike. Now, does that impose any particular obligations on the Japanese crew of that vessel?
Well, any foreign national who's detained by another country's authorities are entitled to be treated humanely, to be treated in a way that their circumstances are in accordance with their human dignity and their human rights. And clearly, if they're in circumstances where their well-being is being threatened, then the Japanese would have to take every effort, and I'm sure they would, to ensure that their health is not at all compromised. I mean, obviously, if they're undergoing a hunger strike, that raises some other issues, but I'm sure the Japanese will do everything they can to ensure that these people are well looked after.
Now, are those sorts of rights, are they enshrined in law, or is this a convention between nations like Australia and Japan?
Well, really, it's general international law that countries they're perfectly entitled to detain foreign nationals if they allege breaches of their own law, but they owe obligations to the country of nationality to ensure that they look after these people properly. This would happen to the multitude of Australians who are detained in various jails around the world. All of the countries that detain them are under responsibilities to Australia to give consular access as appropriate and to ensure that they're in proper accommodation and circumstances, and that would obviously apply here as well.
Okay, well, just to thrash out the theoretical issues then, for argument's sake, what if one of the men developed a life-threatening condition?
Well, of course, we're talking hypotheticals, but one would have thought the Japanese authorities would then be under an obligation to do everything that is appropriate and possible to ensure that person's well-being. Of course, there can never be guarantees about anything. No, one country can never guarantee that another person in its detention will not suffer some illness or whatever. But the Japanese authorities, if there was such a circumstance that you mentioned, would be under obligations to take all appropriate efforts. And to be honest, I have no doubt that they would. The issue here is not so much an issue about trying to do the wrong thing by these people, but I think there are broader legal issues involved. And if one takes the example of Peter Bethune, the New Zealand activist who was also detained on this very vessel some time ago, I heard him interviewed recently, and he said that on board the ship he was very well looked after, and I'm sure that would be the case here as well. Okay,
of course, Australia is already involved in a protracted legal action with Japan. Could these men's actions impact on or even hinder Australia's action that's underway in the International Court of Justice?
That's a very good question. As you mentioned, Australia instituted proceedings against Japan before the International Court of Justice in May of 2010, so 1 3/4 years ago. Those proceedings move quite slowly. The court has allowed for Australia to lodge its papers, which it's done. Japan will lodge its papers by May of this year. It's quite likely that if indeed the case ever goes to a hearing, that is still some years down the track and a decision even further. We're not sure exactly, but it's certainly not a quick end to this one way or the other. Australia, of course, is in a slightly awkward situation because their allegations are such that they allege that the Japanese whaling program in the Antarctic is illegal, is in breach of various treaties, including the Whaling Convention. So that the way that Australia deals with Japan in trying to resolve this issue must be in a way that they don't in some way implicitly recognise the right of Japan to whale, because that may at some point compromise their allegations down the track. They have to tread carefully. On the other hand, also, the fact that Australia has brought this action against Japan, it's quite a big thing for one country to bring an action before the International Court of Justice against another country saying you are in breach of the law. Even where the two countries are good friends, as Australia and Japan is, to do that, there is a political cost to that. let alone the legal risks, but there's a political cost. And one could at least speculate that by doing that, Australia's negotiation and leverage with respect to these three people might be a bit more difficult than it otherwise would be.
Okay, well, presumably the actions of these men has been partly out of concern for the whales in the Southern Ocean, but also partly out of frustration with the time being taken for that action in the International Court to come to some sort of head.
I think that's absolutely right. I think it's broader than that because the International Whaling Commission, which is the body established under the treaty to regulate whaling, and all of the member states of the treaty attend this meeting every year. Those meetings for many years now have been punctuated by disagreement and recriminations with the pro-whaling states on the one hand, the anti-whaling states on the other hand, taking extreme views, and therefore no compromise, no impasse being reached. And so for quite some years now, the IWC, the body that is supposed to regulate whaling, has been a dysfunctional body that hasn't really achieved what it's supposed to do. That therefore allows Japan to continue to whale under this so-called scientific whaling, which is permitted under the treaty. I mean, the question Australia says is that this is indeed not scientific whaling, they're just calling it that. That's a separate issue. Japan is able to claim scientific whaling and continue, and because of the impasse at the regulatory body, there does not seem an end in sight to this. And so I would have thought that this is partially the reason, for the frustration of various environmental groups. They can't see states resolving the issue of whaling. Clearly, they want there to be no whaling, but with a view like that, it's going to be very difficult to convince the whaling states, predominantly Japan and others, to agree.
But the catch-22 is if actions like this are polarising the players concerned, that some sort of compromise position becomes harder to achieve.
That's true. The environmentalists would say, I would imagine, that it's unfortunate these people have been taken into detention, but it's brought the focus back to the International Committee on Whaling. I mean, we're sitting here talking about it on national television. On the other hand, things like this don't help, I don't think, to ratchet down the tension when it comes to such an emotional issue. I think the important point to realise here is, I mean, there are lots of law involved in whaling and its regulation and in these issues, but the whole notion of whaling is highly sensitive, emotional and political, and that requires cool heads. And it's very difficult sometimes in such an emotional issue for people to sit down and compromise. Of course, we all have our own personal views. Personally, I think whaling should be stopped completely. But the fact that we want that personally doesn't necessarily translate into a practical ability to do that, given the legal framework within which whaling currently exists.
And just finally, Steven Freeland, I mean, you've written about this subject before. You see there being some quite serious potential risks, downsides for Australia in bringing legal action against Japan over this matter.
Well, certainly, any case in any court, there is no guarantee. Australia has made fairly clearly stated allegations that Japan is in breach of these conventions. The court will decide one way or the other. The court may decide not entirely in Australia's favour. If, for example, the court were to say that at least part of the action of Japan is lawful within the treaty, then in one sense Australia's lost the moral high ground, and it makes a future negotiation harder. There are other issues that have broader consequences, perhaps for Australia, and that may be issues as to Australia's claims to various waters as being part of its own.
Because we could see Japan actually arguing that Australia's claim over Antarctic waters isn't legitimate.
That may well be the case. Australia is not using its claim to bolster its case before the ICJ for that very reason. But of course Japan, in its responses, and we won't see those for some months still, may bring into question Australia's claims to some part of the Antarctic waters. If in that case the court were to come to a view on that, and if that view were in some way negative to Australia's claims, then of course that has broader potential. It may not get to that. In fact, it may not get to a case hearing at all. There may be a compromise. But I think there are risks associated, but they also, as I said before, compromise the ability to negotiate at this stage.